2018, many months after the Parkland shooting. The charges in this case that the state has filed are as follows: an attempted aggravated battery on a law enforcement officer, alleging that on November 13, 2018, Nicholas Cruz did intentionally attempt to touch or strike Sergeant Raymond Beltran, a Broward Sheriff's Office law enforcement officer, against his will with a deadly weapon, specifically a conductive electronic weapon, knowing that he was engaged in the lawful performance of his legal duties. Count 2 charges battery on a law enforcement officer. On November 13, 2018, Nicholas Cruz is accused of actually and intentionally touching or striking Sergeant Raymond Beltran against his will, while knowing Sergeant Beltran was a law enforcement officer engaged in the lawful performance of his duties. Count 3, the state is charging the defendant with depriving an officer means of protection, specifically that on November 13, 2018, Nicholas Cruz did unlawfully deprive a law enforcement officer, Sergeant Raymond Beltran, of his weapon, specifically a conductive electronic weapon, excuse me, and the weapon was used by Sergeant Beltran as a means to defend himself. Count 4 of the information charges attempted use of a self-defense weapon against law enforcement. On November 13, 2018, Nicholas Cruz is accused of knowingly and willfully attempting to use a non-lethal electric weapon or device, specifically a conductive electronic weapon, against a law enforcement officer, Sergeant Raymond Beltran, while Sergeant Beltran was engaged in the performance of his duty to supervise Nicholas Cruz. Ladies and gentlemen, in the United States, all defendants are presumed innocent. Nicholas Cruz is presumed innocent under the United States Constitution. The presumption of innocence remains with every defendant, including Nicholas Cruz, throughout the course of the trial. It is up to the state to prove that the defendant is guilty beyond a reasonable doubt. Right now, Nicholas Cruz is presumed innocent, and he will remain so unless and until the state proves otherwise. If I were to ask you right now to reach a verdict, your verdict would have to be not guilty, and that is because the state has not presented any evidence against the defendant at this point. At this time, I'm going to ask the prosecutor or the state attorney, assistant state attorneys, and the defense to introduce themselves. State.
Good morning, ladies and gentlemen. My name is Maria Schneider. I am the prosecutor, the assistant state attorney who is assigned to handle this case. My colleague, Ms. Sherry Tate, is here to help me during jury selection.
Mr. Erman, whenever you're ready.
Good morning, everybody. My name is Gabe Erman. This is Jacqueline Browdy. Lisa Lawler is over in the corner, and Gabriella Darden. We represent Mr. Cruz. Ms. Darden, you may see at times running in and out of the courtroom, but she's with us as well. Good morning.
Thank you. Ladies and gentlemen, even though this case is not the Parkland shooting case, I must gauge your knowledge of Nicholas Cruz and the Parkland shooting in order to ascertain whether you can be fair and impartial. Let me begin by saying, if you have never heard of Nicholas Cruz or the Parkland shooting, you're under a court order to please keep it that way. Do not try to go on your cell phone, on your electronic devices and look it up, look his name up, look up any of the places or the people involved. Don't Google Parkland shooting, don't go on Wikipedia, don't post anything on any internet chat site. You are under a direct order not to disclose a word of what has been talked about in this courtroom, and not to research anything of what you learn in this courtroom until you are relieved of your service in this courtroom. So when I excuse you to go back to the jury room and you no longer have to report here, you're no longer under that order. But if I direct you to come back on a different day, you're under an order to not disclose any information to anyone, including your fellow jurors. Don't talk about it, don't discuss it. You may not discuss what goes on in here. It is private, and it cannot be discussed anywhere but inside of this courtroom. Does everyone understand? Please answer out loud. Yes. Thank you very much. By a show of hands, is there anyone here who personally knows, that means has met, either of the assistant state attorneys, any of the defense counsel, or the defendant in this case. I'll start with the first section over here by a show of hands. Okay, for the record, no one is raising their hand, and in the back row over here, there are no hands raised. Next question that I have for you is by a show of hands. Is there anyone here who feels that they cannot presume Nicholas Cruz innocent in this case, based upon their knowledge or feelings of the Parkland School shooting, understanding there's two separate cases? I'm going to start with this section here. Please raise your hand if you cannot presume Nicholas Cruz innocent. In the first row, I have Ms. Brown. And is there anyone else in the first row? There are no other hands raised. In the second row, is there anyone who feels they cannot presume Nicholas Cruz innocent because of their knowledge of Mr. Cruz or the Parkland shooting or of this case? In the third row, is there anyone who feels they cannot presume Mr. Cruz innocent? Okay, so I have Ms. Brown, juror number 2. In this section over here, by a show of hands, I'm going to start with the row closest to me. Is there anyone that feels that they cannot presume Nicholas Cruz innocent of the charges that I've read to you here today? In the second row, is there anyone by a show of hands who cannot presume the defendant innocent? I have Ms. who is juror number 4, juror number 21, Ms. Juror number 20, Mr. Sir? You did? Okay, thank you. In the third row, the row closest to the back, is there anyone who cannot presume Nicholas Cruz innocent of these charges? There's no one who has their hand raised. I'm going to go back to this section over here. Is there anyone feels that for any other reason they cannot follow the laws of the Constitution and presume the defendant innocent? For any other reason? No one has their hand raised? And in the section in the back, is there anyone that feels for any other reason that they cannot follow the law and presume the defendant innocent? Ms. number 7 has her hand raised. Okay, now I'm going to go over the schedule with you in this trial. If you are selected to serve, you are going to be required to be present at the Broward County Courthouse on October 18th at 1 p.m. That's not this Monday, but the following Monday. That's October 18th at 1 p.m. You will be required to serve that day from 1 to 5 p.m., and then that's going to be part 2 of jury selection. If you're selected to actually serve, you're going to be required to serve from the 19th through and including the 22nd. So you should assume that if you make it to the next round, in other words, if you're asked to come back, that you will be required to be here from the 18th at 1 p.m. through and including the 22nd at 5 p.m. Now, I know your juror summons says October 6th, and many of you may have employers, and you're probably thinking, well, my employer is going to see October 6th on my summons, but yet you want me to come back on the 18th. We have absolutely no problem at all giving you additional documentation if you need it for your schools, for your employers, for whomever, showing that you will actually be serving from the 18th through and including the 22nd. I will also add that if you are a full-time employee of a company, they are required to pay you while you are on jury duty. That's all full-time employees. By county ordinance, you're required to be paid by your employer while you are serving, so you should not be having your income withheld. In just a minute, I'm going to ask whether anyone has a great hardship with the schedule that I've just set forth, which is again October 18th at 1 p.m. through and including Friday the 22nd at 5 p.m. A great hardship is, for example, someone who is a single parent who picks up their child at 1 o'clock in the afternoon and has absolutely no one to fill in for that week, which would essentially leave them stranded if they were required to serve. Another example would be a business owner who has no employees and would have to shut down for 5 days, thus greatly impacting their financial status or their financial well-being if they were required to serve. Something that would not be a great hardship would be someone like myself. If I were asked to serve, it would be inconvenient, and I would have to reschedule many of my cases. I would have to have other judges cover for me, but at the end of the day, I would get paid, and I would still have a job to come back to. So that would not be a great hardship for me. And those are, again, just two examples. That's not the extensive list of hardships, but I just want to give you an idea of what I would consider to be a great hardship for, as far as the schedule is concerned. Starting with the first section over here, by a show of hands, does anyone feel they have a great hardship if they were required to return on the 18th at 1 p.m. through and including the 22nd at 5 p.m.? Keep in mind, you're going to be excused for the day here in about 10 minutes. Some of you are going to be. Some of you are going to be asked to go back to the jury room. So go ahead. Does anyone have a great hardship with scheduling? Sure.
It's, if you're scheduled to go somewhere.
Okay.
Is that a hardship?
Like a vacation? It could be. Did you try to when is it?
The 22nd.
Okay, so you wouldn't have known to reschedule it in advance. Do you know what time you're leaving?
I can find out.
Sure. And this is for the record, Miss. Yes, ma'am.
I take care of my daughter's child. Is that an hardship?
Well, if there's no one else to take care of the child, if you were required to be here for a week and there's no one else to take care of the child, you're the only one that can do it, then yes. Hold on just a second. I'm just going to take a show of hands for now, and then I'm going to go back around and inquire of you. Miss Cipollini.
I depart 7 a.m. on Friday the 22nd.
Okay. Thank you. All right. So we have Miss Brown who has raised her hand. How about anyone else with a great scheduling hardship? We have Mr. Just Six. You don't know English? Okay. Thank you, sir. The clerk is telling me that juror number 6, for the record, has brought his brother who was interpreting for him outside the courtroom. Also, I should add, a great hardship would be that you do not have 100% grasp on the English language. In other words, even if you speak English and you understand English very, very well, if you're not able to understand, we need you to be able to understand every word that's said, with the exception of legal words, because some people, including myself, don't know every legal word. Those will define to you. But if you can't understand some of what's going on other than the legal terms that will be defined to you, that would also be a great hardship. Okay, other than Mr. Let's see. Mr. Evan? Okay, hang on just one second. I'm going to just get the hands first, then I'll come back and ask you for the specific reasons, okay? Is there anyone other than Miss that raised their hand in this section as far as the scheduling hardship? Okay, in the second section, let's take one row at a time. The row closest to me, please raise your hand if you have a great hardship for scheduling. So everyone in the first row would be able to come back on the 18th at 1 and serve through and including Friday the 22nd. Okay, how about the second row? I see juror 23. Your English is not good? Okay. And I have Miss. In the third row, is there anyone that has a great scheduling hardship or a language barrier? Mr. Is there anyone else?
So really,
Ms. Rackoff? Sorry, what was your question?
My question is, will you have to come back? Will you have to have a schedule on that date, the 18th, to come back here?
If you have a conflict and you can't be back on the 18th, now is your time to raise your hand and let me know.
I'm not sure what day is the 18th.
It's a Monday. It's Monday the 18th at 1 p.m. Excuse me?
Monday until Friday.
Monday through Friday. Monday at 1 p.m. to 5 p.m. and Tuesday, Wednesday, Thursday, Friday from 8:30 a.m. to 5 p.m.
That's the schedule.
That's the schedule.
I have work like in the afternoon, like 5 o'clock.
You have to be at work at 5 o'clock?
Yes.
And how far is your work from the courthouse?
My work is in the Delray Club. It's Thursday and Friday.
I'm sorry, where is it?
Delray,
Oh, so that's got to be at least an hour, right?
an hour. That's Thursday night and Friday.
So that would be the 21st and 22nd. This is Miss Rakoff for the record. Ma'am, if I were to assure you that we could end at 4 o'clock, would you be able to go straight from here to work and make it there on time?
Yes, I
You can? So you could bring your whatever your work clothes are with you, and would an hour be enough to get from here to there?
can. Yeah, that's fine. You'll understand.
Okay. All right. Thank you. Is there anyone else that I missed that has a scheduling hardship? I see Miss.
Not a schedule, but the language barrier.
You're not understanding everything that's being said? Okay, anyone else that I have forgotten or I haven't seen, or that maybe you have a chance to think about it and you've changed your mind? Going once, going twice. How about in this section? Is there anyone that has had a chance to think about it and realizes that the schedule does not work for them? I see Ms.
I have school at 6, so I just want to make sure that I'll be able to get to school at
What time would you have to leave here to be at school at 6?
5:15, 5:30.
And you could go straight from here to school? Is that a yes?
Yes.
Okay, the following people are going to be excused to return back on Monday, the 18th at 1 o'clock. If I call your name, you're going to stand up and go with the court staff to be returning here and to the jury room on October 18th at 1 p.m. You're going to be given a paperwork that tells the address and where to be and the time. It also has a phone number if you have questions. Juror number 1. Juror number 4. Juror number 5. Juror number 8. Juror number 10. Juror number 12. Juror number 13. And juror number 9. Juror number 14, Mr. Andrade. Juror as beautifully as you do, I don't think. I'll work on it though. Miss Tracy, juror number 22, juror number 25, juror number 26, juror number 27, Juror number 28. Juror number 29. And juror number 32. If the rest of the jurors would just please remain seated for a moment while we excuse the others. If I may please see the lawyers sidebar for just a moment. The individuals who are still with us at this point are going to be excused to return to the jury room where you may be selected to serve on another case. Thank you very much for your time and attention. The staff is going to escort you out at this time. Okay, we have the group number 8.
Judge, it's 1, 2.
Oh, I'm sorry, we're starting today, we're not on 8, and we're not on 7, we're on 2. Because the first group, we're starting over. Yes, because rather than pick up from yesterday, which makes more sense, thank you. To go 1, 2, 3.
I originally had it and I crossed it out when I saw group 7. So.
Okay. So this is group number 2 for what's today? Wednesday, Tuesday. What's today? Sorry. Group number 2.
A2, group 2.
Sorry. Okay. Yes.
Good morning, Ms. McElroy is present. So just so the court knows, we've had a discussion. We're in agreement. We don't need the court to be involved in the discrepancy that we had from yesterday.
Okay, and the discrepancy being between the public defender's office and the press?
Not really a discrepancy between us, Judge. There was an inadvertent publishing, broadcasting of a potential juror's name, full name. And we just wanted to avoid that happening, and it was inadvertent. Ms. McElroy has assured me it's been inadvertent and it's been addressed. So
Who did that?
I don't know. I can't.
What station was it?
Judge, I don't know.
Yeah,
Is it someone who's coming back?
No,
I don't think so.
It was a juror who was excused based on a cause challenge yesterday, I agree too.
One of the ones that was crying?
I saw,
No.
I saw more than one. I'm going to be frank with the court.
More than one name?
Yeah, I saw some bits on YouTube where jurors were being addressed and the name was coming up, but I didn't know that there was a prohibition to publishing the juror's name, so I don't think there is.
It's not, Judge. What my research, and the research has been very brief, shows is that the court has to consider something called Stewart factors, and basically they take into consideration whether there is an intimidation factor for potential jurors. That having been said, Ms. McElroy has assured me and Mr. Erman that it's been addressed. It was inadvertent. Those bits and pieces are being taken down, are being blurbed over, whatever you call it, when they, bleep out certain portions of language, and that they're going to take their best efforts to make sure it doesn't happen again.
Okay.
Judge, I just want the record to be clear that I believe that that's voluntary, and because, you know, at some point, someone's gonna raise the fact that names have been out there, but.
Well, if
as far
it's a
as-
juror that's been excused, there's no intimidation factor because of the fact that they're not gonna be serving. So I'm assuming if they're talking to the press, it's by their own free will.
Oh, no, they're not talking to the press. I'm saying there were snippets of the proceedings yesterday that I happened to see on YouTube because people sent them to me.
Okay.
And jurors' names, other than the one juror that you guys are talking about, jurors' names were being said. I don't know if those are jurors that are coming back or not. I didn't think to look that up. But what I'm trying to place for the record, and Ms. McElroy can correct me if I'm wrong, I don't know of any legal prohibition regarding the jurors' names being public, whether they're serving or not. Am I correct in that, Ms. McElroy?
You are correct in that, but our understanding at this point is that the feed, Court TV, that is the full camera for this, is attempting to, and can't catch every single thing, but is attempting to bleep out or silence at least the first name, and trying, and so what happened is that's what they're doing voluntarily, and
But you don't represent Court TV, do you?
I don't, but why I'm here today is to address, it was a potentially broader request, and so what I agreed to do is get in touch with, I believe it's Law&Crime, that was carrying the live feed and had the YouTube snippets, and ask if they would voluntarily, remove.
I appreciate that because that's not your client either, is it?
Well, it may be my client.
Oh, you don't know.
Right, they're not my client right this second, but I
get it. Okay.
So I just said I would step in and try because it had broader implications for the group I do represent.
Well, yeah, because the thing is, you can just let them know that the chief judge has been very, very, very accommodating, and you see all these cameras, and we only have to have one and one. So maybe you should let them know that if they keep doing that, that we won't be as accommodating.
Right, that's coming from the feed, is my understanding. So I can, talk to them and.
But they have the ability to put that on or not.
Right.
So if their source is going to be limited, if they don't cooperate, then that might be an eye opener. If you understand what I'm saying.
I do. I hear you.
I don't want anybody coming back here saying I saw my name on TV and now I'm scared, so I can't serve.
Is it first and last name, Your Honor? Because I believe, I'm not sure what they're doing on the feed. I can check, but it's, it's in real time that you're addressing the jurors.
I understand. So they have to bleep it out as I say it.
That's right.
Well, I usually don't call them by their first name. I call them Mr. or Mrs. So-and-so.
Okay.
But I can, I'll just call them Mr. or Mrs. So-and-so. To me, if it makes it easier, I won't say their first name. I did say a few first names yesterday when I was trying to clarify which juror it was.
Judge, in any event, I'm only aware of one.
Okay.
I only saw one snippet.
Okay.
That included the name of someone who was excused yesterday.
Okay.
Ms. Schneider was very clear that she saw other snippets and so
Okay.
there were other names. I have no way to stand here before the court today and say that someone who's coming back on the 18th isn't.
All right. Well, we'll
telling
see.
anybody
We'll see what happens.
We'll have it.
We'll play it by ear. I appreciate you helping out where you're not required to.
Definitely, Your Honor. Thank you, and I appreciate them letting me know. And would it be possible, if, like you said, to, refer to them either by just last name or anonymously at some point?
I thought of that, but I don't think they know their juror number. Do they?
No.
They don't know that.
I think the best is last name and seat number.
Their seat number is what is their juror number, but they don't. I mean, they can see it when they sit down. But if I say number 4 and they're sitting on it, they're not going to probably remember.
Just a suggestion.
We might be able to do that for next week when we have a bit more time, because then what we'll do is we'll give them a card with their number on it as they sit down and let them know that we're going to refer to them as juror number 1, juror number 2. You know what I'm saying? Because I don't know about you, but if I sit down on a card, I might look at it in 2 seconds. If I'm not paying any attention to it, I'm not going to remember. I'm going to get up and keep looking, especially if I'm like number, 27. I might not automatically remember, but we can have a card for them to hold in their hand starting next week, and we can do it that way. But today I will just do the last name.
And thank you.
And they're not showing their faces? Oh, so if it's a last name and they're not showing the face, I think that.
Judge, but to the extent that's possible, for them to not, just to blurb out any names as they do it, that would be appropriate. I don't happen to agree with Ms. Schneider that it's a very clear-cut, cut and dry rule as to.
Well, there definitely has to be an evidentiary hearing on it, which we definitely have not had, so.
Right, I understand, and because of the agreement that Ms. McElroy's given and the attempts that she's given, I don't think it's necessary right now, but it is something that needed to be brought to the court's attention, I guess, and certainly to Ms. McElroy's attention.
I've asked Law&Crime, they've said they're going to either edit out or take that down, and
But their faces are not on it, just me referencing the name.
that's my understanding. I haven't watched the whole thing.
Okay,
yet.
so I will make sure just to reference the last name, and this community is so large that we even have had a number of jurors on the same panel of 32 with the same last name. So if it's just the last name and then you're not showing them, and it happens inadvertently, I'm not that concerned with that. I thought you meant they were showing the faces and then saying their name. Which most people won't remember anyway, because they show my name and face all the time, and I can tell you no one ever recognizes me, which is a good thing. Outside of court, because obviously I don't wear my robe around to the grocery store.
Unfortunately, Judge, I think that this garners attention that people will perhaps tune in a different way.
Okay, thank you. Yes? Excuse me? Ms. McElroy, my bailiff has offered to number index cards right now and put them on the seats with an into court TV. Would that be much easier to just say number 1, number 2? So am I going to call them Mr. Number 1? Mrs. Number 2?
I don't have an issue with surname and or seat number. Mr. Smith, juror number, in seat number 1. I mean,
I think that's probably
that's
fine and
fine.
better.
But I think what they're saying, Court TV and the news is saying that because they're playing it real time, they're having to go beep or whatever it is each time I say it, so that they might miss one. If I say, sometimes I say, I have a script that I'm trying to go off of, but sometimes I say, oh, excuse me, I mean, and then I correct myself. And probably those are the instances where they don't catch it. Do you know what I mean?
Judge, I think that it's, we need to be sure that we're being accurate as far as who's who.
Okay,
Making sure
all
we're
right.
accurate, I think that's the bigger issue.
All right, we're gonna go with with the surname, and we just won't show. Thank you, guys. I keep getting head nods and thumbs up from the media telling me that they're following along, which I very, very much appreciate. You all have been extremely professional, and I appreciate it very much. Okay, so we'll go with the surname. As long as you're not showing the faces, the surname. If a few get slipped through, I don't think that's a problem. There were very few names that were. I think there was a Greek name that was rather difficult, or a Eastern European name that was hard to pronounce. But those are the only ones I can think of that were very unusual.
One more issue, if I may, Your Honor.
Sure.
We have a proposed order from yesterday that
Okay.
everyone has read and agreed to.
Okay,
If I may submit it to the court
sure,
for your consideration.
sure. And lawyers, we're on, how many do we have?
You have now a
86.
total of 86.
Well, you're good, because that's what Horton says. So I'm thinking at 100-ish. Well, excuse me?
I'm sorry, I didn't realize Mr. Cruz is in the back.
Oh, I didn't either.
I was over talking with.
I'll start over in a minute when he gets back, okay? and then to the wrong side. So I had to call her number. But what I would prefer is you kindly bring the person a tissue and take them out as quickly as possible without making a scene. Maybe I should designate this to D. Hart. You know what I mean? I don't want the person like, hey, sir, you're excused. I would like you to please be as nice as possible without causing a scene.
Before we bring the next group in, the state has a matter to bring up.
Okay? Whenever you're ready.
We just observed that coloring pencils and a page for what appears to be a coloring book was just brought up for the defendant. We're objecting to that, Your Honor. We believe that that is something that they're doing so that the jury perceives that, he's a child or he has a, some kind of, his mentality is somehow challenged. We think that's inappropriate and we object to a coloring book page and coloring pencils being given, just provided to the defendant for him to use. Yesterday, he was writing down the names of the jurors and making notes on the one of these sheets that the court has provided us to use as a chart of jurors. He was very oriented apparently to what was happening, and now today we believe that the defense is trying to avoid the appearance of him participating in jury selection.
Have you brought a coloring book and crayons for the defendant, Mr. Ehrman?
I have not, Judge. I have not brought them.
Somebody did that?
There are colored pencils. There's no coloring book. There are colored pencils here, and there's
I'm sorry, Mr. Ehrman, I can't hear you.
there's no coloring book, and there's no
I
crayon.
say coloring book, I said coloring, it's a page.
Oh, I'm sorry.
It's a page.
Is there a purpose for that as far as assisting Mr. Cruz in keeping up with jury selection?
There's number one, he's not using it. It's just sitting there right now.
So why does it need to be sitting? What is the purpose of it?
Just I have a brief moment to respond appropriately. I just have a brief moment to confer.
About the purpose of the
Yes,
book
I'd
and
like
the
to confer with
crayons?
my fellow counsel.
Okay. Jurors ready to be brought in. Mr. Ehrman, are you ready to address this coloring issue?
I can address it.
You can or you
I
cannot?
can.
Okay.
Yeah, sorry.
That's okay?
Number one, we take issue, and there is a concern if the media and the state is saying what he's writing. The state's now saying that we see him writing yesterday on the jury sheet. The state doesn't need to be concerned with what my client is writing and what notes he puts and what color pencils. I have multiple colored pencils here as well and pens. The state shouldn't be concerned with what he's writing or what I am writing.
I want to interrupt you for one moment. There was one news clipping that I saw. And the headline was something to the effect of Mr. Cruz is participating with his lawyers or concentrating or taking a role in jury selection, and I'm not quoting it. And you could see him, and he was looking very closely at the paper, and he was writing. You could not see the paper, you could not see the writing, but everybody could see that, and that was a headline. So my question is, why does he need colored pencils and a drawing paper?
Judge, he's clearly upset. He's visibly upset right now. I'm trying to keep him calm during this trial, and the defense team is not doing this for any nefarious reasons. I'm trying to keep my client calm. He just asked for 2 minutes to himself. I said I will address that with the court in a moment, but I wanted to do this argument first. Judge, right now, there's nothing that he's doing. His hands are crossed. He's not drawing. He's not writing. There's
Okay,
nothing
so
going
as
on.
long as he's not coloring with crayons as if he's a child, that's fine. But that's not appropriate because if he wants to take notes, that's fine. If he wants to sit there, that's fine. If he wants to participate, that's fine. If he wants to be quiet, that's fine. But as far as coloring pictures on a picture book, that does not assist him or you in selecting a fair and impartial jury. It gives an impression that he's a child.
Judge, may I address something briefly in addition?
Let's go one at a time. I'm first talking to Mr. Ehrman. I understand there are multiple lawyers, but when we're addressing a certain issue, I would appreciate if one lawyer could go at a time. It's hard for me when there's 2 or 3 lawyers that are jumping in. Mr. Ermine, you haven't answered my question. Are there crayons or a coloring? Okay, the jail is telling me for security, he needs to be using the pen that's issued by the jail. So that solves
Show
it.
the court what was on the defense table.
Okay, that is not for him to use for security reasons. The jail says he only can use a pen, their pen.
I just wanted the court to know that these are not crayons, they're colored pencils. When you say, there's no Crayola box here.
Okay.
Okay.
If those are being used by the lawyers to color code the witnesses, the jurors, that's fine. The jail is telling me for security reasons, there's 2 issues. One, he can only use the pen issued by the jail. I guess the jail issued him a pen. Is that right? Excuse me?
We will be issuing him a pen.
A pen. They have to issue the pen because it's gone through security. That's number 1. Number 2, there was a laptop that was stacked on top of books. It's down now, but it needs to remain down because the sheriff's office has brought to my attention that the folks that are in charge of viewing him at all times can't see him when that laptop is stacked up on top of a couple of books. So for security reasons, I would appreciate those 2 things being abided by, and we are ready for the next group.
I was unaware that a pen was issued by BSO.
I wasn't either. They just told me.
And in fact, Judge, yesterday we provided Mr. Cruz a pen here at the table. That happens daily in this courtroom, in this courthouse, with every defendant in this courthouse. That having been said, at this table, I understand we're all a little crowded. We're trying to do the best that we can. I'm trying very hard to not have my laptop open to the media. I'm trying to not have it open to the potential jurors. And so if a laptop was where it shouldn't have been, we're sorry.
That's okay. I'm just asking that for the reason that I stated, that you just please keep it on the table, on your lap. I'm happy to give you file folders if you want to put it on the side so no one can see. I can accommodate you in whatever way I can, but the security needs to be able to see Mr. Cruz. And if I didn't know about the pen, that's my fault. I'm the judge. I should have known that. They're telling me now. BSO is in charge of security, so he needs to use the pen that's provided to him.
So do they have one to provide him right now?
There's one that's always on the table, and here is the pen. This is what I was given. Gives to him. He has one
It looks
here. there's
exactly
an extra.
like the one he's been using. Thank you.
That's what I left on there.
Do you want me to clarify?
Judge, I'm not trying to impede with
No,
BSO.
no, but you know what? This is the thing, we've been more than accommodating. That pen, yes, is a normal pen. I'll give you that, but 1 pen, and then we can see at all times. Okay? It's for not only our security, but yours too.
I understand.
Okay.
But I'm saying that's
I
what
mean,
he
we can
has.
go
One pen.
sidebar, and I will give you examples. of
Okay,
why.
all right, we don't have to go any further. Deputy, we're all good. Just if you have something that's not being followed by or abided by, let me know right away,
Yes.
because I will defer to BSO every time when it comes to security, unless it infringes on Mr. Cruz's constitutional rights, and we can always work it out. I'm not one of those judges that doesn't listen to BSO. I know better. I know you're in charge of security. I have no problem with that, and I will stand by what you feel you need to do for security reasons, okay?
Your Honor, thank
And I'm sorry about the pen. I should have known that.
you. We will have one issue tomorrow.
Thank you so much. Thank you. Mr. Ermine?
I just want to be, in no way am I trying to impede upon, I'm going to deal with BSO for.
I think we're all good.
with-
Everybody is a little bit, overwhelmed, myself included, because this is sort of a large process as compared to perhaps another trial. And there's a lot of components, working components. Everyone yesterday did a wonderful job. I'm very impressed with the professionalism on everyone's part, including the sheriff, the public defender's office, the state attorney, the clerk's office, everybody. So,
Sorry,
go ahead.
I thought you were done.
No, that's okay.
Judge, as we saw yesterday, as we saw again first thing this morning, there's clearly a number of jurors who come in that are crying and visibly upset. You asked about accommodations. I'm asking if the court would accommodate Mr. Cruz for 2 minutes to have some alone time to gather his thoughts for 2 minutes before we bring in the next panel.
You told me that it's been more than, okay.
You want by himself.
Okay, 2 minutes, not a problem. Sheriff's Office, is that okay?
I have no problem with that.
Okay, thank you, sir. Thank you. Thank you. I'll have copies of the third group for today, if you want to start writing it so that we can back-to-back call these people in.
Are we going to get to a third group? I thought we might stop at 2.
Yeah, I think we went from 1 to 2.
We're gonna go 1, 2, 3, because remember, I'm trying to get to 100, but remember, we have a number of folks that were already calling yesterday that were asked to come back, so I'm anticipating, I mean, I'm being generous, I think, by using this number, but I'm thinking perhaps 10, we'll have like 10 no-shows, so I'd like to get like a little bit over 100,
Okay. Yeah.
Just
We'll
so
get
that-
to 100 with the next one.
just so that we have 2 groups of 50, and then we can socially distance in the other courtroom.
Okay.